Friends, I'm now reading excerpts from the book Evoking HM Seervai, Jurist and an Authority on the Indian Constitution. The book has been compiled for his centenary by HM Seervai's wife, Firoza H. Seervai, and this book was brought out by Law and Justice. Its first edition was in 2005, and then there have been reprints in 2021, 22, and 2024. I would like to thank my friend Manish Arora bringing out this book and sending it to me. I read to you from page 23 of this book, which is a portion written by senior advocate T.R. Andhyarujina. Early in his professional career, he, that is Homi Seervai, showed his fearlessness when he felt that a certain senior judge of the High Court was favoring his son by running down the son's competitors. Seervai took up the cause of the bar and demanded that the Chief Justice should move the judge from his then assignment to another, which the Chief Justice eventually did. Later, Seervai opposed the giving of a reference to the judge when he was elevated to the Supreme Court. Older members of the bar recall that Seervai was conspicuous in the bar library by his ebullience and confident and emphatic pronouncements on cases and on the issues of the day. He had a remarkable self-assurance in his own opinion and judgment. He was gifted with an extraordinary memory and would recall entire passages of English prose and the poetry of Milton, Wordsworth, Keats, and Tennyson with ease. He had a sure command of the English language and a quick, logical, and incisive mind and a hatred for superficiality. There was hardly any litigation in constitutional law prior to the advent of the Indian Constitution in 1950. Seervai, like the rest of lawyers at the Bombay Bar, busied himself in commercial law litigation, which thrived in the city of Bombay. Strangely, he confessed that initially he had no inclination for constitutional law, a field in which he later distinguished himself. His logical mind found more attraction, he said, in the law of evidence and contract law. Moving to prohibition cases, in the early 1950s, the government of Bombay, prohibition laws came under attack in the state's High Court. In an important case, Seervai was engaged as a junior by the government to defend the Bombay Prohibition Act with the then Advocate General Mr. C.K. Daftari. Seervai told me that Daftari, who relished his peg of whiskey every evening, had really no heart in defending the government stand. At a bar function in 1950 to celebrate Republic Day, Daftari, as Advocate General, is reported to have joked that a republic without a pub was only a relic. On the other hand, Seervai was a lifelong teetotaler who detested alcohol and had seen families ruined by the evil of drinking. So defending such a cause was natural to his inclination. It fell to Seervai's lot to make the final speech in the case. He did it with great vigor and conspicuous success. The then Chief Minister of Bombay, Morarji Desai, was a moralist and fanatical believer in prohibition. Though temperamentally apart in their outlooks, Morarji Desai saw in Seervai the right defender for the government's action in unpopular causes like prohibition and the requisitioning of premises. Seervai was thereafter much sought after as counsel for the government in a number of cases. In 1956, Seervai was briefed to defend the government of Bombay's decision to ban prize competitions, which were in reality lotteries. In the case of RMD, Chamar Bogwala was the state of Bombay. Seervai was unsuccessful both in the trial court and in the appeal court in Bombay, which held that the ban was illegal. Undaunted, Seervai advised an appeal to the Supreme Court. The government's appeal came up before a constitutional bench of the court. The government attached considerable importance to this appeal and therefore briefed C.K. Daftari, who had by then become the Solicitor General of India, with Seervai as his junior. By a stroke of good luck for Seervai, Daftari was not prepared to argue the case when it reached hearing, and it fell to Seervai to conduct the appeal. Seervai was completely prepared and only too eager to argue the case. He did it with total dedication for several days and with a spectacular success. The case involved difficult and complicated questions of extra-territorial operation of state laws, interpretation of legislative entries in the Constitution, the scope of the fundamental right to carry on business in gambling, interstate trade and commerce, and the question of severability of unconstitutional statutes. Seervai was opposed by a formidable galaxy of lawyers, including M.C. Seetalwad, the then Attorney General for India, Sir Nussair Vanji, Engineer, N.A. Palkhiwala, and others. Single-handedly, as usual, Seervai argued for the constitutionality of the ban. The Supreme Court unanimously set aside the judgment and orders of the Bombay High Court with costs throughout. Thank you.